My name is Kyle Westerman, and this is for EDL 850, Module 12, talking about tort liability. Tort liability is a legal obligation of one party to a victim as a result of a civil wrong or injury. This can either be done on purpose or um, not on purpose, accidentally. A tort liability arises because of a combination of directly violating a person's rights and transgressions of a public obligation causing damage or private wrongdoing. Evidence must be evaluated in court hearing to identify who is a tortfeasor or a liable party in the case. And my first court case that I looked at was Mitchell versus Cedar Rapids Community School District. What happened in this is that the mother of a special education student sued the school districts for damages the student sustained in an after-hours off-campus sexual assault. The jury found that school district was negligent in failing to adequately supervise the special education student and awarded damages. What happened is a special education student skipped a block or a period of class and left with a friend, and the school district or the teacher marked them absent in their computer program that says whether or not they're present or not. But the school district or the school itself didn't communicate with the parent that that student was missing. And what ended up happening is that student went to several different homes and hang out with some different people that were either used to be a part of the school or still a part of the school. And she ended up being raped by another special education student from the school who was already out of school by the day. And since the school did not notify the parent in time that their student had, or their child had been skipping class, the jury found that the school was negligent by not doing so. The second one that I looked at is Johnson Johnson versus the school district of Millard. Robbie Johnson, a first grader at Willie Cather Elementary School, was injured while attending his music class. They were practicing the song London Bridge while doing actions to it. While Johnson was swinging, two children accidentally released their hands and threw Johnson into a bookcase, and he got a cut above his right eye and had to have some stitches. The teacher did not see this happen and was actually writing on the board, and he and another student testified that she had her back to the children when the accident occurred. The teacher testified that she saw Johnson caught within the children's arms but did not witness that he being swung. And again, a jury awarded the plaintiff money because the teacher was not paying direct attention to what was going on and had not warned them about the dangers of screwing around and what could happen if a kid were to fall down, and didn't have her classroom set up in a way where a student wouldn't get hurt. The third one, case that I look at was Bratek versus Millard School District. Darlene Bratek brought a wrongful death action against the defendant school district after her son David died following an accident in physical education class. What was happening was that the school was in their PE class was practicing golf. David happened to miss the first day talking about instructions and safety and how to swing a golf club and stuff like that. And there were several students, over 50 students in this class, but we had two teachers. One teacher was working with the girl golfers on one side of the gym, while the other teacher was working with the boy golfers. That one teacher that was working with the boy golfers was helping one specific student. And when the kid David asked another student for some help, the kid was showing him how to swing the golf club, how to hold it. And what happened is that he swung the golf club, and David had moved into his swing, and the golf club hit him in the neck, and he rendered him unconscious, and he died 2 days later. The trial court entered judgment for Bratek and awarded damages totaling of $53,570. Again, the reason for this is because the school district or the teacher themselves did not put in place, since he missed the first day of instruction about safety and stuff like that. They did not teach him right, and there weren't proper protocol in maintaining contact and eyewitnessing of students And so for not watching them close enough, that is why the the court issued the way that they did. The fourth one that I looked at was Glasher and Glasher versus Emporia Unified School District. This is a personal injury action brought on behalf of Todd Glasher, a seventh grader at the middle school in Emporia, Kansas. He was not usually on a bus, usually dropped off by his parents, but he rode the bus this day and he was chased off the bus by another student. He ran off school grounds into a public street and he was actually hit by a car. Glazier had settled his claims against the driver, but then sued the school district for not maintaining contact with the student and making sure that they were okay. And where the court found was that since the student had not entered the school yet, that the school was not at fault for how Glazier handled the incident, and so the school was not found at fault for what happened that day. And my last one is Collins versus Bargier Parish School Board. During noon recess, Eugene was playing on the horizontal monkey bars when another student wrapped his legs around Eugene and causing them both to fall, and Eugene suffered a broken femur in his left leg. Recess at the Plantation Park Elementary School is taken several times daily for kindergarten students in a fenced-off area of the playground approximately the size of a football field. The duty teacher is in charge of about 100 students, and Collins argued that the school board and its employees were negligent in the supervision of the recess period, and it's directly led to Eugene's injury. The trial court awarded Collins $13,000 in interest against the kid that made him fell, but did dismiss the suit against the school board. They found that since there were actually less than 100 kids on there and only having one person in charge of those 100 kids, it wouldn't have mattered how many adults you would have had watching those kids, that this injury wouldn't have been stopped. And so they actually decided on the side of the school board in this case, but did charge the family of the other student that caused the injury. In the evaluation of all three of these, my reaction to the lawsuits is the schools will need to revisit all policies and procedures when it comes to supervision of students. A staff meeting will be called to reiterate the importance of consistent monitoring of students when in the care of the school. I think this is extremely important, and it's something that as teachers, especially me at the high school, I tend to think that they are young adults and that they should be able to police themselves a little bit, but it'll end up being my fault if anything were to happen to those kids if they weren't under my direct supervision, whether I'm in the classroom with my back to them or whether I left the classroom for some reason. Any proactive measures that would need to be taken would be proper training and instruction for each school employee. I think teachers really need to be let known and taught how important their presence is and how important it is for them to make sure they're maintaining constant contact and monitoring of their students, because they could be liable for anything that happens. I don't think that's preached enough to teachers. I don't think it was in my case or where I'm at. I don't think it has been taught enough. Examples of these cases need to be shared with staff to show how quickly something can happen, and proper evaluation of all rooms and school grounds to make sure all school grounds are properly maintained. One of the cases that I read about that I didn't put in my PowerPoint was one in Alaska where a student tripped over some roots and stumps that were left that the district didn't clean up, and actually punctured him in the eye and caused some brain damage. And the family was awarded $4.5 million, plus another $180,000 for the family's just pain and suffering because the school district didn't clean up those stumps well enough. And so I think that's important as well, is to make sure that you're constantly looking at your school grounds and your school classrooms as well to make sure that there's nothing in there that could harm a student if an accident were to happen. And then lastly, a set of professional ethics would be important in cases of tort liability because you can prove that your staff have been taught the required standards of behavior. It may reduce the school district's liability if the teacher acted outside of the set professional ethics. So in other words, if I, as a principal or administrator in my school, have set forth a set of professional ethics that my teachers need to abide by, and they know those and understand those, and they act outside of those, the blame or fault may lie on the teacher for deliberately disobeying those professional ethics or going against those professional ethics, and it may reduce the school district's liability if there were an accident to happen. Thank you. Have a great night.